Assalamualaikum warahmatullahi wabarakatuh. My name is Shariffah Afiqah binti Long Matnur Aminuddin, and I want to thank you to Professor Matia Dr. Haji Muhammad Shahnawi bin Muhammad Piruz for giving me this opportunity to present my slide. And today, I will be presenting regarding industrial relations, regulations, and cybersecurity in INC500. And my cases of law on cybersecurity is analysis of Awesome Broadcasting Sdn Berhad versus MYTV Broadcasting Sdn Berhad. Today, I will be discussing on 4 contents regarding this issue. That is facts of the case, issues of the case of cybersecurity, judgment of the case, and analysis and critique. Based on paragraph 1 to 6, this case concerns a legal dispute between Awesome Broadcasting Sdn Berhad, the plaintiff, and MYTV Broadcasting Sdn Berhad, the defendant, regarding the suspension of digital terrestrial television (DTT) services. The case explores the intersection of corporate contracts, regulatory frameworks under the Malaysian Communications and Multimedia Act 1998, MCMC Act, and procedural issues concerning the exhaustion of domestic remedies before resorting to judicial intervention. From the facts of the case based on paragraph 1 until paragraph 25, MYTV Broadcasting Sdn Berhad is the sole government-backed provider of DTT services in Malaysia. Awesome Broadcasting Sdn Berhad was licensed by the Minister for Communications and Multimedia to broadcast video and television content using the DTT platform. In 2020, Awesome Broadcasting entered into an access agreement with MYTV to use DTT services for an annual fee of 6 million ringgit. A supplemental agreement followed in 2021. After the initial agreement expired, the services continued on a monthly basis at 500,000 ringgit per month. By April 2022, Awesome Broadcasting began defaulting on payments. Despite partial repayments, it failed to settle arrears between February and October 2023, accumulating 5,038,191 ringgit 78 cents in debt. MYTV, after obtaining approval from the Malaysian Communications and Multimedia Commission (MCMC), issued a suspension notice to Awesome Broadcasting. Awesome Broadcasting filed a right action and secured an ex parte interim injunction to prevent MYTV from suspending services. At the inter partes hearing, MYTV argued that the court had no jurisdiction as the matter fell within the purview of the MCMC Act, and that the plaintiff had not exhausted its appeal rights under the Act. For the issues of the case is number 1, jurisdiction. The reference paragraph I took 26 to 32, 42 to 47 is the core question is whether the High Court has the authority to hear the case. Since the dispute involved regulatory matters under the Malaysian Communications and Multimedia Act 1998, MCMC Act, MYTV argued that the MCMC had exclusive jurisdiction. For the legal principle, courts typically require plaintiffs to exhaust all statutory remedies, such as appealing to the appeals tribunal, before seeking judicial review. And secondly is the procedural prematurity. The defendant argued that the lawsuit was filed prematurely. The plaintiff had the option to appeal the MCMC's decisions, including the suspension approval under the Section 121 of the MCMC Act, but did not pursue this before filing for an injunction. The key point of this number 2 is that the law emphasizes that plaintiffs must follow all administrative channels before turning to the courts. This is referred from paragraph 35 to 36, 42 to 47. And number 3 is the necessary parties. I referred this paragraph from 52 to 55, where the MYTV contended that the MCMC should have been named as the defendant in the suit. Since the suspension was approved by MCMC, excluding them from the case meant that the court could not issue a meaningful ruling. The legal principle for this is all parties affected by or involved in a decision must be included in the proceedings. The omission of MCMC was deemed fatal to the suit. Number 4 is serious question to be tried. where I reference this paragraph from 26 to 32, 42 to 47, where Awesome Broadcasting argued that there were serious issues to be tried, including unfair pricing, inequality of bargaining power, discriminatory practices, breach of contract. However, the court ruled that the MCMC had already reviewed and dismissed these claims. The court found that no substantial legal questions remained. Number 5 is adequacy of damages. I reference this from paragraph 42 to 47, 52, and 55. The plaintiff argued that monetary compensation would not suffice if MYTV suspended the services. The defendant rebutted that any losses from advertising or broadcasting could easily be quantified and compensated. The court found the financial remedy to be adequate, further weakening the plaintiff's case for an injunction. Now, let's focus on the judgment of the case, where the court dismissed the plaintiff's application for an injunction and ordered damages to be assessed. Here are the key findings that I found. Based on the paragraph 35 to 36, 42 to 47 is number 1, premature application. The plaintiff had not exhausted the available statutory remedies under the MCMC Act, including appealing to the appeals tribunal before seeking court intervention. This procedural lapse was fatal to the injunction application. Number 2 is from paragraphs 22 and 44. Jurisdiction of MCMC, where the MCMC had already considered and rejected the plaintiff's complaints regarding unfair pricing and had authorized MYTV service suspension. The court upheld that disputes concerning regulatory decisions must follow statutory appeal and mechanisms. Number 3 is necessary parties. The failure to include MCMC as a defendant contravened the principle that all affected parties must be part of the proceedings. This omission undermined the plaintiff's claim that there were serious issues to be tried. This is referred from paragraph 52 to 55 and 58. And lastly, number 4 is a balance of convenience. The court found that the balance of convenience favored the defendant as the plaintiff's debt was undisputed and the suspension was lawful under the access agreement. And this based on paragraph 49. For analysis and critique, this is based on paragraph 42 to 47, 49, 52 to 55. The ruling underscores the critical role of regulatory bodies in overseeing disputes within their statutory frameworks. The court's decision to dismiss the injunction emphasizes the principle of exhaustion of domestic remedies, a cornerstone of administrative law. By requiring the plaintiff to utilize the MCMC Act appeal processes, the court reinforced the importance of adhering to legislative intent and procedural rigor. From an analytical standpoint, the strength of the judgment is the judgment affirms the separation of powers between the judiciary and specialized regulatory bodies, preventing unnecessary judicial interference in administrative matters. The insistence of including necessary parties, MCMC, reflects sound procedural governance, ensuring that all relevant stakeholders are present in legal disputes. And for potential critique, while procedurally correct, the dismissal could be perceived as overly rigid, potentially disadvantaging smaller entities like Awesome Broadcasting, which might lack the resources to engage in protracted administrative appeals. The court might have provided more detailed guidance on alternative reliefs available to the plaintiff while awaiting the outcome of statutory appeals. And nevertheless, the ruling highlights the delicate balance between corporate governance and regulatory oversight, reinforcing the judiciary's reference to specialized tribunals in technical disputes. In conclusion, the case of Awesome Broadcasting Sdn Bhd versus MYTV Broadcasting Sdn Bhd provides a really valuable insight into the procedural nuances of administrative and corporate law. The judgment affirms the necessity of exhausting statutory remedies and adhering to procedural norms, reinforcing the legal principles governing disputes within regulated industries. This case serves as critical reference point for future disputes involving regulatory bodies and commercial entities operating within Malaysia's broadcasting and telecommunications sectors.